Hi there. I'm going to give you a quick update on the Sunny Balwani trial. And I'm also going to answer some of the questions that you've asked me. And one of them's a doozy. So keep watching. And please do subscribe, support my work, share these videos, like them, hit that like button and that notification bell. Okay, so who am I? I'm Michelle Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. She's the co-defendant of Sunny Balwani. She was tried separately and convicted of 4 counts of fraud. He is facing, Sunny Balwani is facing the exact same 12 counts of fraud relating to making misrepresentations to investors, to patients, and he's also, some of those counts related to conspiring with Elizabeth Holmes to defraud patients and investors. Okay, so we'll see what happens. All right, so here's the update. Before I get to those questions, the update is there was no trial today. The trial is resuming next Wednesday, March 30th. The jury comes back next Wednesday, March 30th. There's no trial on Tuesday. The trial is also scheduled for next Friday as well. But what's happening on Tuesday? That is scheduled for the defense's motion to dismiss. And we'll find out what are the reasons for wanting to dismiss Balwani's case. And I'm sure at that hearing on Tuesday, I imagine, again, this is just my opinion, and this video is just for information and educational purposes, and I do want to hear what you think, what your analysis is. So please do leave a comment and question. Okay, so at this hearing on Tuesday, the judge, I'm sure they're going to be talking about that open the door issue relating to the missing database, because in opening statement, the defense brought up the missing database and said that the government was dragging their feet and didn't get into the evidence, implying that the government is at fault. But what do we know? We know the judge ruled previously that the government isn't at fault relating to the database. The government was given a database without the code. They were not able to get into the database. It was unusable. Right? But the defense mentioned it in opening statement. Prosecution objected that the defense opened the door. And when you hear the term open the door, that means the party's getting into an area they're not supposed to be getting into. Right? The judge previously limited, you maybe mention the database like they did in the Holmes case, but not get into what happened to it. For whatever reasons the judge, made that determination. So here's where we're at. The defense brought it up in an opening statement. The judge has said it's a serious issue that they need to address to figure out how they're going to deal with the fact that it was brought up. It is the judge, and I talked about this in my previous video. What's the remedy? The remedy is to tell the judge it's called a limiting instruction, tell the jury how they can take this evidence. You can consider this evidence for X, Y, and Z, but you can't consider it for that. In the worst case scenario would be a mistrial if the judge found that it was so prejudicial towards the people that they had to, have a mistrial. But here's the issue with the mistrial, if that would be granted, is whether or not double jeopardy applies, such that, double jeopardy in the U.S. Constitution, Fifth Amendment, defendant can't be tried twice. He's already being tried right now, right? If there's a mistrial, double jeopardy attaches once the jury is sworn. So whether or not Balwani could be retried. And I'm not saying a mistrial would happen at all. I'm not even saying that no one's even brought it up. Neither side has requested a mistrial. The judge has just indicated his opinion that it's a serious issue they have to deal with regarding how they're going to deal with the defense opening the door. And that's not to say that the defense, did it intentionally or did anything wrong. I mean, this happens, when you're standing in front of a jury and, you're trying to get it all together in your head. And sometimes you say things and sometimes, you were told that you could talk about this evidence, but you can't get into the rest of the story, so to speak. Right? And sometimes you make a mistake. Maybe that's what happened here. I don't know. But we're left with the door is open. So now when the door is open, does that mean the prosecution can now explain what happened to the database? Or is the jury just left with this, what happened, this question? Maybe that's a possible seed of reasonable doubt. Maybe it's planting reasonable doubt, bringing up this database, right? Because I said in the prior video that in my opinion, the database, which contains the results of the patient's tests and the results of the quality control tests, that would be the best evidence to say whether or not this technology and the testing was accurate and reliable, right? But they don't have it because they don't have the code, it was dismantled, etc. So, what's the judge going to do? It's up to the judge to decide whether they let the prosecution talk about it, what happened. And the judge has previously ruled it was not the fault of the government. The government was not at fault regarding the handling of this database. That was relating to how it was being handled by other parties, okay? So, question is, I was asked, and this is a shout out, this is a question I was asked. Do I think, and it's a shout out to Hugo Byrne and Hope 46SF, whoever that is, right? You guys make up your names, I'm sure, right? So, does the missing database, mentioning the missing database, does that help Balwani or not? Well, I call it, it's the missing evidence defense, right? So as I said earlier, if it's the best evidence, you don't have it. Are you supposed to convict Balwani? Is that reasonable doubt that we don't have all the evidence? The evidence that, he could point to and possibly say that proves that it was accurate and reliable. There was no fraud here. We didn't make any misrepresentations. Is that maybe what that means? I don't know. You let me know. So, if it's missing evidence, maybe that amounts to reasonable doubt in the minds of one or more of the jurors, such that Balwani doesn't get convicted. I don't know. We're going to find that out. What's the other reason for bringing it up? The missing database and saying that the government dragged their feet? Well, that's pointing the finger at the government, right? Blaming, possibly blaming the government for the mishandling of the database or not having the database as evidence for Balwani. Well, the judge has already previously ruled, the government wasn't at fault. So I'm sure the judge will address this, and I'm sure both sides will address it on Tuesday and figure out how they're going to handle this and how they're going to explain it to the jury or what the remedy is, what the appropriate remedy. And I'm sure the judge will decide that. Okay, so in relating to the mistrial, when I talked about that, mistrial is like the worst case scenario. Neither side has asked for a mistrial. Nobody's brought it up. I just talked about it and for purposes of just letting you know about a potential remedy. Worst case scenario, if the judge finds there's prejudice, to the people, that enough prejudice, or that the judge would determine and grant a mistrial. So, back to the issue around the mistrial is that does double jeopardy apply, right? Is he going to be, he's being tried right now in the United States, Fifth Amendment, defendant can't be tried twice for the same crime. So he's currently being tried, he's on trial, right? So if there was a mistrial, the question is, does double jeopardy? Would double jeopardy prevent him being tried again? So, that was just an educational discussion we were having. All right. So I don't think it's a mistrial. We're not in the mistrial area. We're in the area probably of the judge instructing the jury on how to take those remarks made by the defense and whether or not the prosecution can present evidence as to what happened. And if they do, it's not blaming, if they do and say that it was the mishandling by Theranos or some other third party, right, that the database is not available, or the access to the database is not available, then the prosecution explains that the defense can get up and say, well, my client's not at fault either. Assuming they say this, I'm just, talking to you about this. They could say, Balwani's not at fault. Balwani had already left Theranos. He had nothing to do with the handling of the database. And they could point the finger at someone else other than their client. So we'll see what happens. We'll see if that happens. Okay, so let me get to question. This is a shout out, and this is a good one. Another good question. Shout out to Christopher Cripps. He said, quote, the defendant should not benefit with a mistrial and a dismissal with prejudice, not being able to be tried twice, because of the misdeeds of his own counsel. Interesting comment, right? So, is Balwani benefiting from, the alleged misdeeds? I'm not saying the defense made a mistake, but it's certainly, they opened the door, right? So, do you think Balwani should benefit from the misdeeds of his own counsel? And, it happens. It happens sometimes. Judge makes a ruling and you are, making your presentation or you're in trial and you make a mistake. Sometimes that happens. So whether or not it's a mistake or a misdeed, I'll leave that to the judge. Okay. So next question. Shout out to Eddie. Eddie asked, in Erica Chung's cross-examination about her not getting assigned to, she was not assigned to the R&D. Initially, she went into R&D and then they switched her to the CLIA lab. The defense was bringing this up in cross-examination, I guess to point out that she was upset. I guess to imply that she was a disgruntled employee, therefore she's making all of this up about the inaccurate data or the testing. So I say this, that Erica Chung, I watched the Holmes case. Erica Chung wasn't the only one who talked about the problems with the testing and the technology. So, maybe you could say that, maybe you would say Erica Chung, and I'm not saying this, maybe you could imply Erica Chung was disgruntled, but the thing is there's other witnesses corroborating. Other witnesses in the Holmes case corroborated what Erica Chung said. So I don't know how effective that was. I don't know. And again, it's just my opinion. All right, now here's another question, and here's the doozy. Here's the doozy question. It's relating to Ian Gibbons. Do you remember in opening statement when I said, you go look at the opening statement video, when the defense said that Sunny Balwani learned the technology from the scientists at Theranos, and that Ian Gibbons, I have to look at my notes, it's Friday, that Ian Gibbons told Balwani that the technology could do all of the 4 categories of tests. So Balwani was relying on what the scientists told him about the technology. I'm assuming this is what they're saying, implying. Balwani relied on the technology, what he learned about the technology from the scientists, and he was told by Ian Gibbons that the technology could do all of the 4 categories of tests. So allegedly, how was Balwani to know that there was problems? So here's the question, though, or here's the concern, is that was there someone else present during that conversation where Ian Gibbons told Balwani? Because tragically, Ian Gibbons committed suicide. So who's going to testify that Ian Gibbons told Balwani that the technology could do all 4 of the categories of tests? Who? Who can testify to that? And they also said, in opening statement, the defense, that Balwani never made a dime from Theranos. He didn't sell any shares of stock. He never made a dime. Well, who can testify to that? So these are interesting questions. So what happens if you have a witness who's deceased? What do you do if there's only 2 people in the conversation and it's the defendant and Ian Gibbons? So my question to you is, will Balwani take the stand? And does Balwani have to take the stand? That's my question to you. Does Balwani have to take the stand? How are they going to get in this testimony, assuming they get over the hearsay, an out-of-court statement offered for the truth, the conversation, the statement that Ian Gibbons made to Balwani, assuming they get that in, who's going to testify to that? Does Balwani have to take the stand? That's my question to you. What do you think? I look forward to reading your answers and to all the comments and questions you leave. So, again, please do subscribe, share, hit the like button, and hit the notification bell. And thanks again for watching.